Hi and Assalamualaikum. My name is Amir Aiman, and today we are going to explore about a very interesting case of Lok Kok Beng and 49 others versus Loh Chiak Eong and another. This case comes from a large industrial development project involving purchasers, a developer, and an architect. At the heart of the dispute is a simple but important question. Can an architect, in this case Mr. Loh, uh, can he be held responsible in negligence for losses suffered by purchasers, Mr. Lok Kok Beng and 49 others, even though he never dealt with them directly? So, without further ado, let's figure it out. So, in understanding a legal case, we have to first understand the facts first. So, this case begins with a large industrial development project where a group of Malaysian entrepreneurs, namely 50 of them, including Mr. Lok Kok Beng, purchased factory units with hopes of starting their business. To secure their own units, the 50 purchasers entered into sale and purchase agreement (SPA) with the developer responsible for this very project. Following the agreements, the construction of the industrial development project began under the developer's management and the appointed professionals. Yet, over time, however, the project did not progress as expected, and completion was delayed beyond the original date. And somehow, eventually, the development reached a stage where the physical structures appeared substantially completed. So the developers invites the purchasers to look around the industrial development project. At this point, it has been over 24 months, and based on the sale and purchase agreement, the SPA, it is required to deliver the vacant possession to the purchasers within 24 months. So at this point, the 50 purchasers believed their factory units were ready for handover and awaited for the delivery. However, beneath the surface of the factories, there remain an unresolved regulatory requirement affecting the project. The CEITS system, Central Effluent Industrial Treatment System, which is a centralized wastewater treatment facility required in industrial developments. And it was discovered that the wastewater treatment system did not meet the required environmental standard. There was also an inspection by the relevant authority, the Department of Environment, Jabatan Alam Sekitar, which confirmed that the system of CEITS was non-compliant and approval for operation of the factory could not be granted. This further prevent the industrial development project from obtaining their CFO. For the context, CFO stands for Certificate of Fitness for Occupation. It used to be a legal certificate issued by the local authority, the PBT, like DBKL, MBPJ, MPAJ, and etc., confirming that a building was safely constructed, complied with approved building plans, and suitable for people to live or utilize it. And in this case, architect Loh was the one involved in overseeing certification for the project's completion. And the developer asked architect Loh to complete on the matters of certification for this project. However, the architect did not certify the project as compliance of the CEITS water system requirement had not been yet satisfied. And obviously, as a result, the 50 purchasers of the factories were unable to take possession of the factory units they had contracted for. This further led to a frustration among the purchasers, and question arose over who should bear responsibility for the delay of delivery of their factory. This dispute eventually escalated and was brought before the Malaysian court for resolution for the purchasers. However, the federal court ultimately held that architect Loh was not negligent, finding that the legal requirements for imposing a duty of care on him were not satisfied. We'll learn and figure it out further on the court's verdict. When determining whether architect Loh owed a duty of care to the purchasers, the federal court first examined the requirement of proximity. In negligence law, as we learn, foreseeability alone is not enough. Even if a person could foresee that their actions might affect someone else, a duty of care will only arise when there is a sufficiently close and proximate relationship between the parties. The purchaser argued that they suffered losses because the project was delayed and the architect should therefore be liable. However, the court carefully analysed the relationships involved in this project. The dynamic is that the 50 purchasers, entered into sale and purchase agreements with the developer, not architect Loh. Their legal relationship was directly with the developer who was responsible for delivering the completed factory units. Architect Loh, on the other hand, was not a party to those agreements. He was appointed separately by the developer as a professional consultant to perform architectural services. This distinction was important because the architect's duties arose primarily from his professional engagement. The purchaser had no direct dealings with them, no contractual relationship with them, and no special relationship that would justify imposing a legal duty of care. Hence, the federal court concluded that the connection between the purchaser and architect Loh was too remote. There was simply insufficient proximity between them. And as a result, the first requirement for establishing a duty of care was not satisfied. Without sufficient proximity, no duty of care could arise, and without a duty of care, a negligence claim cannot succeed. The second reason why the purchaser's claim failed was that their loss consisted entirely of pure economic loss. Okay, first we have to understand what is pure economic loss. It refers to a financial loss that is not connected to personal injury or physical damage to the property. Courts have traditionally been cautious about allowing recovery for this type of loss because it can potentially expose defendants to extensive and unpredictable liability. In this case, the purchasers claim that the project delays caused them various financial losses. These include additional financing costs, loan repayments, lost business opportunities, delayed investment, and other economic disadvantage arising from the late completion of the development. However, the court observed that none of the purchasers suffered physical injury. None of the purchasers was injured as a result of the architect's low conduct. Likewise, there was no damage to any property belonging to the purchasers. The losses claimed were therefore purely financially in nature. This distinction is significant because the law of negligence has traditionally been more willing to compensate losses arising from personal injury and property damage than losses that are purely economic. The federal court therefore characterized the purchaser's claim as one involving pure economic loss only, and as the claim was based solely on financial losses and was not accompanied by personal injury or neither personal property damage, this became another strong reason against imposing liability on architect law. The third, and I think perhaps the most important reason considered by the federal court, was public policy. Even where a loss is foreseeable, the court must still ask whether imposing a duty of care would be fair, just, and reasonable to do. This requires the court to consider the wider consequences that its decision may have on society, professional practice, and the administration of justice. The court recognized that architects perform an important professional role. They are expected to exercise independent judgment when assessing whether legal, technical environment, and regulatory requirements have been satisfied before certifying a project. If architects were exposed to negligence claim from large group of purchasers whenever a project experienced delay, several undesirable consequences could arise. First, architects might feel pressured to certify projects prematurely simply to avoid future lawsuit. Instead of exercising independent professional judgment, they may prioritize reducing litigation risk. Secondly, professional independence could be undermined. Architects must be able to make decisions based on compliance and safety consideration rather than fear of legal claims. Third, public safety and regulatory compliance could be affected. If architects are pressured into approving projects before all requirements are satisfied, the quality and safety of the development may be compromised. And finally, imposing liability could expose architects to indeterminate liability. A single architect could potentially face claims from hundreds or even thousands of purchasers, creating an unfair and unpredictable burden. Taking all this into consideration, the federal court concluded that public policy weighed against imposing a duty of care on architect law. Therefore, even if the losses were foreseeable, broader policy consideration made it inappropriate to impose negligence liability in this situation. The key lesson from this part of the case is that negligence law is not concerned solely with compensating losses. Courts must also consider the wider impact that recognizing a duty of care would have on society, professional practice, and the public interest, most importantly. When the federal court looked at the case as a whole, all three factors pointed in the same direction. There was a foreseeability, but there was insufficient proximity between the purchasers and architect law. The claim involved only pure economic loss, and public policy consideration opposed imposing duty of care. For those reasons, architect law was found not liable in negligence. Thank you very much for listening to my podcast. Listening to my presentation. I hope you guys enjoyed it, and I hope you guys learned something as I did. Thank you very much. Thank you very much. Assalamualaikum. How to stop?